Good morning.
Good morning.
I hope everyone's doing well. We have 3 cases scheduled today, and welcome to the First District Court of Appeals. The first case we have is Ohio versus Brown, which is case number C190399. If both parties can please identify themselves for the record and their readiness to proceed.
David Hoffman for the appellant, Your Honor, ready to proceed.
Thank you.
Alex Haviland, Your Honor, for the state of Ohio, also ready.
Thank you. Good morning, Mr. Hoffman.
Morning.
Or Attorney
Morning.
Hoffman. Would you like to reserve some time?
5 minutes for rebuttal, please.
Okay, whenever you're ready.
All right. Can the court hear me all right at this volume?
Very well, thank you.
I represent Ms. Brown, Lanai Brown, and she was prosecuted and convicted for making statements in a judicial proceeding, basically. And that's privileged, and she shouldn't have been subject to criminal prosecution for it. The offense she's convicted of is tampering with records, and it involves as elements that she falsifies, destroys, removes, or conceals, or defaces, or mutilates a writing. And part of the elements that have to be proven by the prosecution in this case are that they had to prove that she knew at the time that she had no privilege to do this. And that's the point in my sufficiency claim that I'm making. There was no evidence that she lacked a privilege, and that she knew that she lacked a privilege.
Well, she knew that she was lying in the civil complaint, right?
Well,
I mean, it was completely false information, wasn't it?
It was false information. The investigator testified that that in her opinion, she felt that my client knew she was lying. My client testified that she just didn't understand the law, and practically speaking, she would never be able to occupy this under her understanding for the time period required for her to take legal title. And so she testified that she just made a mistake. But
wasn't it up to the trier of fact then to determine whether she in fact knew it was false or didn't know it was false?
Well, sure, Your Honor, but the point I'm trying to make is that under this court's case of Whitman versus Gerson, she wouldn't have been even subject to a counterclaim for slander of title, let alone getting indicted for it. I mean, even if this was knowingly false, it couldn't happen. She didn't file anything in the recorder's office. These were statements in a judicial proceeding that were privileged, and the state just didn't prove that she lacked a privilege in making these statements, and that she knew it. There's just no evidence.
Your position, doesn't it basically just allow anybody to file a complaint, avert a lie that they know, or for facts that they know are absolutely not true and not accurate, and then just be able to, hold someone into court?
Well, you have Civil Rule 11 sanctions that apply to pro se litigants. You've got Title 23 attorney's fees that you could slap on somebody for doing that. There are remedies civil remedies that are exceptions to this privilege that we've put in the law to prevent that kind of thing. And I think that just because this is a criminal proceeding, you can't say, well, there's no privilege because it's a criminal proceeding, because all the other cases are defamation cases. And just say, well, because this has been captioned as a criminal case, therefore there's no privilege, is circular reasoning.
But you can't lie. You can't lie under oath, right? I mean, that would subject you to a perjury charge. So lying in a civil case certainly exposes you to criminal liability, doesn't it?
Yeah, and also if you're in a criminal case, if you testify, you can incriminate yourself, and so you can get in all kinds of trouble making statements in a judicial proceeding. But the general rule, those are exceptions to the general rule. I mean, for example, with self-incrimination, before you could use those, you'd have to warn the person, and then they'd go forward and go ahead and testify, or they could claim their Fifth Amendment rights. But the general rule is that that statements made in a judicial proceeding are privileged, and it's an absolute privilege. And so that privilege existed in this case, and my client was not subject to criminal prosecution or even a counterclaim for slander of title. So that's my position.
What about the prosecution's argument that there needs to be some sort of good faith? I mean, you can't just put any lie in a complaint. It's got to be in good faith. And so those would be the only situations in which somebody would be prosecuted, as if they brought up a complaint that was not in good faith. So it kind of limits the time that somebody would be prosecuted criminally.
Well, under the Eaton case I cited, they pointed out that doesn't work all the time in practice, because when you have retaliatory litigation, it's hard to defend yourself to prove that the lies you made were intentional, or they just turned out to be, you lost the case. And so that's why it has to be in practice an absolute privilege. And so I would say that wouldn't work. So if there are no further questions, I ask that the court reverse and discharge for lack of sufficient evidence. Thank you.
Good morning, Attorney Halvin.
Good morning, Your Honor. Sorry, I was finishing a note.
Okay.
I'll start just also right away with the sufficiency with regard to the privilege. Judge Krause, you just brought up, I think it's important to consider, I think, several things. A lot of the cases I point out that are cited by the appellant come from the defamation law. I think there are public policy considerations in place in defamation realms that are certainly not in place here. I think, Judge Krause, as you brought up in the Baumgartner case that I cite, even if there is this presumption, I guess, of privilege, I think it is necessary that it be limited to those proceedings that are instituted in good faith. And I think here, there's no question that this underlying quiet title action was not.
And Attorney Halvin, going to your point a little bit, because looking at the language of Rule 11, it says that when the pro se party is signing, they're certifying that to the best of their information and belief that there is good ground to support it meaning the filing, right?
Correct.
So is good ground to support the filing the same as that the underlying facts are true and accurate, or is it different? Because good ground to support it, what is the it?
I think it's the action, the gravamen of the action. Why we're so in this, if I understand your question correctly, I think it's the attempt to quiet title on this house in this case.
So so if the it is the action, right? Good grounds to support the action, then how would you then distinguish this case from the language in Rule 11?
I'm not sure. Perhaps I'm not understanding your question.
In other words, this case, there's a lot of case law out there with sanctions with regard to someone who files a cause of action and the cause of action was not well founded, not because the facts were purposefully not accurate, but because there really wasn't a remedy under the law or that sort of thing.
Sure. Okay.
Okay. This isn't an issue where there's not an remedy under the law. The issue before us is a case where where the party files a complaint that if the facts had been accurate, she would have a cause of action potentially, right? But the facts were not accurate.
Correct. I get.
So going back to the language of Rule 11, I find it interesting that the language says that the pro se party is asserting that to their belief that she has good grounds to support it, and it seems to be the cause of action.
Yes, in terms of levying sanctions? Is that what we're?
What I'm saying is that the same thing as a lie, or is that only saying that the cause of action isn't it? In other words, does that distinguish the cause of action, good faith that we believe we have a cause of action, versus good faith that the facts that underlie that cause of action? Is it inextricably intertwined, or are those two separate things?
I'm not certain, and I apologize, Your Honor. I haven't prepared. To my understanding, she's not been sanctioned in any fashion. This hasn't been raised in any of the briefing.
Right.
I don't, regardless of what it
But
says.
the argument is that the remedy is provided in Rule 11. And
Sure,
so
and
we
I
need not go further than Rule 11.
I completely disagree with that. I don't think we had to file sanctions. I think we probably could have. Someone could have. I think a lot of things could have happened. Perhaps, as Judge Krause mentioned, perjury. This was an affidavit that was sworn to, that then under sworn testimony, she said, yeah, that was all false. I don't think that we're, pegged into choosing one course of action throughout this. What we did was charge her with, she was convicted of the tampering. She was charged with theft and unauthorized use, I believe, also.
Mr. Devlin, if this was not privileged, where do you draw the line? Because aren't there often factual misstatements or outright lies in civil complaints? And are you suggesting that anytime there's a fact that's false in a civil complaint, the person or the lawyer is subjected to criminal prosecution?
I don't think so. And I think, I think the distinction is kind of what I was saying before. If there's a good faith basis for that and something turns out to be false in a civil filing, I don't know that's necessarily actionable in a criminal case. I think in this case that it's abundantly clear there was absolutely no basis for any of this. And so if someone were to file another one of these, I think certainly they could be subject to criminal law. And I guess, Judge, it would be a case-by-case basis, and I don't know a definitive line.
Go ahead, Judge Myers.
What, for example, let's say it's a conversion case, a civil conversion case, and the person says, Mr. Havlin stole my diamond ring, and I file that against you, and I know it's false. I know you didn't steal my diamond ring, but I bring an action for conversion. In that case, would that lie, if I make it knowingly, subject me to criminal prosecution?
I suppose it could, yes. I mean, I think it would depend on if you're, I think the distinction with this case is we don't have as much, the theft is going in the wrong direction. So there's not as, we don't have, I'm not sure what the, I guess, purpose behind that would be. But yes, I think if the facts meet the elements, and there's been no challenge to this statute, this crime, as unconstitutional in this case either. So
what did she put in the complaint that was false?
Let's see, the first paragraph 7, I think, is the first, and I could be missing some, it's long. In paragraph 7, she claims to be the recorded legal owner of the property. Paragraph 9 claimed that the victim refused entirely to make any future mortgage payments, and he clarified that by saying, no, I did miss some, but I was in conversations with Caliber, I believe is his mortgage company, about the mortgage modification agreement. Paragraph 9 also claims that he permanently abandoned the property. He denied that. And then on paragraph 10, she claimed she entered the property and claimed title. 2 of those things in her own testimony, the claim to be the legal owner in paragraph 7 and the claim to have entered the property in paragraph 10, she said that was false while she was testifying. So there's her admission to those being false, coupled with the witnesses from the state, the victim and the police officer. I think just I guess a lot of this comes back to a policy thing, and the court in Baumgartner explained it, the bare possibility that a proceeding might be instituted is not to be used as a cloak to provide immunity in these cases. I think, Judge Zayas, to your question before, this could veer towards allowing anyone to file any civil action and then therefore be barred by any criminal prosecution or other even civil defamation or things like that. So it
does seem to open up a lot of prosecutorial discretion, though, doesn't it? Because it just seems like the prosecutor's office can just determine which cases they want to file criminal charges in.
I think it probably does, yes. And I don't know that this is certainly probably not as clear a case as some other more familiar criminal codes, burglary or something. We get that generally, or a plain theft. But I think the legislature did an okay job trying to, these are hard things to perhaps put four corners on all the time.
And Attorney
Is this a
Havlin-
case of,
I'm sorry, Attorney Havlin, how far did the case go in the civil proceedings?
I don't know that a hearing, there was a response filed by the victim. I don't know that it ever even came to a hearing. I believe that, if perhaps Mr. Hoffman knows, I believe she never appeared. I don't know if it was set for one and she failed to appear,
Okay.
but it was dismissed.
So the truth and veracity of the allegations of the complaint were not really determined in the civil proceedings. They were the subject matter of the criminal proceedings.
No, yes, there was never any hearing, any adversarial hearing in the civil case. Well, I don't believe much, if any. It's possible the only part of the record in that case that we have is State's Exhibit 1, the quiet title action. I don't know that, I'm not sure much else happened. So yeah, all of the facts that we have came just through the testimony in the underlying criminal proceeding.
So I
is
think
this a
that
case
goes-
of first impression?
I'm sorry. So I think that goes to the argument of Attorney Hoffman of, the filing of the complaint and the privilege. Because in this case, if the allegations were not really determined in the civil proceedings, then doesn't that open up for any time that it's believed that there might be something that is not accurate in the complaint to subject the plaintiff to criminal proceedings?
I guess it could, and I wish I had I think it would depend on the circumstances of that hypothetical filing, as I've discussed with Judge Myers about the conversion. I don't know. I don't have an answer for all of them, but yes, it could. If it's something in line with the facts of this case, I think
Thank
the
you.
state could then seek to prosecute.
Thank you.
Is this a case of first impression, Ohio, as far as you can find?
I believe so. I don't, as I explained, a lot of the privilege cases cited in the merit brief of the appellant were defamation. In the reply brief, there's one Isaac, I think that's a second. I don't recall the district that's in, but that was a criminal mischief or something. That was dealing with a truck. Someone was trying to break into a truck and the state called the person driving the truck versus the title owner. So that was more of a lack of demonstrating privilege in that sense. I don't believe, I'm unfamiliar with one where it's a filing in an unrelated civil matter.
Often these cases that involve a similar fact pattern, the person has actually attempted to file a deed or has forged a deed. And so therefore the statute's been applied in that way, as opposed to a civil action where the same result is attempted, but where there hasn't been a forged document other than, I know your allegation is the complaint is what gives rise to it here.
Correct. Yes, I believe I did not find another case in Ohio that was on all fours with this one. If I don't know how much time I have, just briefly, I guess I will mention the
You
restitution.
have 2 minutes.
Okay, in the third of assignment of error, it's my position, that the language of the statute does not require the specific amount to be announced verbally.
How's a defendant supposed to litigate that if they don't know the amount that they're required to pay in restitution?
I think you can request a hearing at the outset. That's obviously their right to have a hearing to it. The plain language of the statute in the first, I'm not sure how many sentences are between these, but the first sentence says in open court. The one talking about the amount just says at sentencing. Sentencing does not occur until the filing of the entry.
So a judge can just say, you owe restitution, not give an amount, and then just decide an amount and put it on the entry later?
There has to be, the amount has to be based on evidence in the record. It's itemized in the statute. It can be receipts, things like that, representation of the victim and other things. I think the amount in this case came from the victim's testimony. The cases cited, Lowe, Purnell, and Wilson, those were all cases that this court overturned the restitution order because the amount was left to be determined later by the probation department. I think that's the distinction between this case and those. If there are no additional questions, I guess I'd simply just ask that this court affirm the trial court's decision.
Thank you.
Thank you.
Attorney Hoffman.
Your Honor, I don't have much more to add. I can answer the court's question if the court really wants to know about the outcome of the civil case. But if you'd rather I not digress from the record, I'll just leave it be. It isn't in the record, but it was a motion to dismiss filed because my client didn't allege half the things she had to say for an adverse possession case. And so it was dismissed for failure to state a claim upon which relief could be granted.
There wasn't testimony on the procedural posture of the civil case and the criminal case?
I'm sorry, how's that, Judge?
Was there testimony of the procedural posture of the civil case within the criminal case, the tampering with records case?
I don't recollect it, Judge. I don't think so. My client testified that she didn't show up and it was dismissed. And I can't recollect the testimony of I think Mr. Halleck testified that he hired an attorney, or he had his divorce attorney filed a pleading. He might have said that she had it dismissed, but I can't be sure.
But that was the $1,500, right? The restitution was for the attorney fees?
That's correct. He said around $1,500, and it was part of his testimony, and that was above and beyond what he paid for the divorce. I mean, that was specifically for the work she did in this case. I mean, that's the impression you'd get from reading his testimony. So, but beyond that, I can't remember specifically if the procedural posture of this civil case is a part of the record in the criminal case.
And on the restitution, your client was able to, I mean, that was litigated, right? The prosecuting witness testified that he was out $1,500. Apparently he provided some receipts. So that could have been litigated at the sentencing hearing, correct?
Well, he testified to around $1,500. I don't remember receipts being in the record. I don't think those are parts of the state's exhibit. Okay. I don't think receipts were provided. And just a bland statement of restitution, even if it wasn't contested during the trial, even if there wasn't, contesting information or testimony, contradicting testimony, just a blanket statement that restitution is owed, I think it leaves the door open for whatever could be demonstrated in trying to prove it after that, and in order to satisfy the order. I think that the amount has to be stated. It has to be announced at the sentencing hearing in order for a full opportunity to either contest it. I mean, if the amount isn't stated how's a person going to know they need to ask for a hearing to contest the restitution? They might not.
Well, the judge did say that she owed restitution and that he was going to order restitution, right?
What was the beginning part of your sentence, Judge? Sorry.
The judge at sentencing did say, I'm ordering restitution. I mean, it was discussed. It just, your issue is the amount wasn't stated.
That's precisely right. Yeah.
So at that point, she could say, well, I want a hearing on it.
Well, she could have done it. She could have done it if she had remembered the testimony about the 1,500 in the trial, I guess, and if she thought that that would be the amount that the judge had in mind when he ordered restitution. And I think that's all conjecture. I think from a policy standpoint and in the facts of this case, the amount had to be stated at the sentencing hearing. If there are no further questions, I'd ask that the court would, based upon the first assignment of error, reverse and discharge due to insufficient evidence on the element that I discussed. If there are no further questions. Thank you.
Thank you. Thank you for both of your arguments this morning. We will take the matter under submission, issue you a timely decision, and we wish you both a wonderful afternoon.
Thank you, Your Honor.
Good morning.
Good morning, judges.
Morning.
So the next case that we have is Douglas Hayes, Administrator versus Durrani, MD. This is case number C190617. If both parties can please identify themselves and their readiness to proceed.
Good morning, Your Honors. Robert Winter on behalf of the plaintiff. We're doing Hayes first rather than White. Is that correct?
That's correct.
Okay, let me get the correct file then.
Okay. Are both parties here for both cases?
Yes, ma'am.
Judge Zayas, this is Russell Sayre speaking. I will be arguing only the Hayes case, which is the one up next. My law partner, Philip Williamson, will be arguing the second case, but he will be doing it from this spot.
Okay.
And by the way, am I audible enough to the court?
Yes, you are. Thank you.
All right, I think I'm ready now.
All
My
right.
apologies.
No worries. So we have Attorney Winter for the appellant, Attorney Sayre for the appellee. Attorney Winter, pardon?
Yeah, yes, Judge.
Did I mispronounce your name?
Just a little bit.
Okay, what was it again?
Sayre, S-A-Y-R-E.
Sayre, I apologize, Attorney Sayre. Thank you.
I'm very used to it, Judge.
As am I with my last name.
It's usually Sayre.
So Attorney Winter, would you like to reserve time?
Like yesterday, 2 minutes.
2 minutes, okay, whenever
Sure.
you're ready.
Okay. Good morning, judges. Bob Winter on behalf of Douglas Hayes as administrator of the estate of William Hayes, the deceased. The principal issue here today is during a jury trial, the trial court excluded evidence of Dr. Durrani's flight from Ohio to Pakistan and refused to give a flight instruction
Mr. Winter, can I stop you really before you even start? Let's say that we agree that a flight instruction should have been given because it goes to evidence of liability or guilt, in a criminal case, guilt, liability. Isn't it harmless error because the jury, in fact, found liability, found that the doctor was negligent? And according to the interrogatories, their verdict was based on no causation. So the flight instruction wouldn't go to the element of guilt because that was in your client's favor.
It would go to liability. That's
And
true.
didn't the jury find in your client's favor on that issue?
That's my recollection, Your Honor. Yes.
So
Yes.
what error is there in not giving the flight instruction?
In this case, it doesn't sound like there would be any because the jury did find liability notwithstanding the absence of a flight instruction. Yes. And the causation is the causation. It was a matter of fact. That's right. That's my recollection of it too. And the issue also would go to the ability to cross-examine. The absence of this evidence would go to the inability to cross-examine Ronnie and Cass experts, where we have the same matter that you've just talked about, Judge Meyer. The fact that this would not go to causation.
Right, thank you. And I
So-
wanted you to address that before you got into the rest of your argument. And thank you. And that's the only question I had.
Okay, well, you blazed the trail for me, Judge Meyer. What we have here is the absence of a flight instructions or evidence of flight, simply because the trial court ruled in a pretrial conference and follow-up order that no such instruction will be given. But in fact, it passes the relevancy 403 bad act evidence rule because it deals with evidence of flight or evidence of guilt, a guilty conscience. And in this case, Dr. Ciani and Dr. Bloomfield presented evidence of reckless, if not falsified, imaging. And I would think that one would run away from that responsibility or liability also. And dealing with the 806 argument, all that Dr. Durrani had in terms of evidence coming in was his medical records, and then his experts saying, well, we have no reason to disbelieve them. Well, there is reason to disbelieve them. And this matter would, the flight would have a bearing on, should have a bearing on those experts giving credence to Dr. Ronnie's reading of the imaging. So I think that's my case, judges, and there's no need to beat a dead horse.
Thank you. Attorney Sayer?
Thank you, Judge Zayas, once again, and may it please the court. My name is Russell Sayer, arguing on behalf of Appalese, Dr. Atik Durrani, and the Center for Advanced Spine Technologies. I'm going to depart from my prepared remarks to comment that I think that Judge Meyer's question to Mr. Winter was exactly the correct one and is exactly the issue here. The jury did find, or the verdict was based on the jury's conclusion that although negligent, Dr. Durrani did not cause the injuries claimed by plaintiff. In other words, that negligence on Dr. Durrani's part was not the proximate cause of any harm to appellant, that appellant did give informed consent, that Dr. Durrani did not commit a battery, and Dr. Durrani did not fraudulently misrepresent the need for surgery. And you can find that in the record in the transcripts of proceeding volume 8, starting on about a page.
Attorney Sayer, you've muted yourself.
Where did you lose me, Judge? I'm so sorry.
10 seconds ago.
I'll just press the reset button and keep going. Appellant was understandably disappointed by the verdict, especially a verdict that found negligence but no causation. So we have to ask ourselves, why then do the appellants complain about the failure to give a flight instruction? Well, appellant's brief spends many, many pages reciting a litany of supposed wrongdoing, some of which convinced the jury, some of which did not. The jury was not convinced on the issue of causation and the other causes of action other than negligence.
Can I interrupt you there? Because those other causes of actions where they didn't find liability, could the flight of instruction have made a difference on those? And if so, why shouldn't it have been given?
Well, the flight instruction does not plug the causation gap. The jury found that notwithstanding negligence on the part of Dr. Durrani and a specific finding of negligence on the part of Dr. Durrani, that he was not the cause of the plaintiff's injury. Giving a flight instruction would have done nothing to plug the causation hole. It is simply evidence that Dr. Durrani might not be the most admirable human being on the planet, and that is not a causation substitute.
What if they had found there was a lack of informed consent, and they did that in part because the flight instruction had been given? Never answered the causation question with respect to informed consent, for example.
Well, the hypothetical you pose, what if the jury had not found in favor of the defendant, I'm sorry, of Dr. Durrani on the issue of informed consent, or are you positing that it had not?
I'm sorry, I thought, and maybe I'm misremembering, I thought they found in favor of Dr. Durrani on the liability of informed consent.
The jury verdict in the transcript of proceedings, I just gave you the site, found that Dr. Durrani did give informed consent, and therefore we never had to get, obviously, to the causation point of perspective. But
and I guess my question went to, could it have made a difference to the jury on that issue if a flight instruction was given?
Well, I'm quite prepared to acknowledge, Judge, that it might have, and that's the problem. Because it doesn't do admitting evidence of flight, although it might have changed the jury's opinion of Dr. Durrani and then perhaps the verdict, doesn't do anything to prove or disprove whether the patient here, Mr. Hayes, gave informed consent. Appellant argues when he gets to the issue of flight after a recitation of Dr. Durrani's sin, he untethers himself from the record and makes the pronouncement that Dr. Durrani fled the United States to avoid civil liability to Mr. Hayes and others, and that excluding evidence of Dr. Durrani's flight was the sole cause for the defense verdict. And that comes from page 1 of the appellant's brief. So what you're hearing from the appellant here is that we would have won if we had been in a position to persuade the jury that Dr. Durrani was not an admirable man. And that, with all due respect to appellant, has nothing to do with the issue of informed consent. And appellant never gets in his briefing to a plausible explanation of what Dr. Durrani's flight had to do with any of these claimed injuries. Mostly, appellant's litany of Dr. Durrani's sins focuses on his practices around record keeping and other paperwork, arguing that they were not accurate. But the jury, as you know, concluded that that was not a cause of any injury to the appellant. So appellant casts about for an explanation for the defense verdict and would have the court conclude that the problem was that the exclusion of the evidence of Dr. Durrani's flight must have been the problem and the only problem with appellant's case. What appellant wants the court to do here, I think, is create new law in Ohio. He wants you to require trial courts to admit so-called flight evidence in any case in which the defendant is no longer in the state of Ohio at the time of trial. And he wants you to do so by fiat and unmoored by any Ohio legal foundation in any event. There's no statutory basis offered. There's no rule with such a requirement. And he points to no other court that has imposed it. And in fact, the appellant ignores the fact that the opposite of his proposed rule, could it have made a difference, is the actual rule. So-called flight evidence is only rarely admitted. And the reason for that is that it is extraordinarily prejudicial. The trial court was correct in the exercise of its discretion, and that's the standard of review here. I didn't hear that before. And it certainly did not abuse its discretion by admitting, or rather excluding, the evidence in this case. So appellant's argument here depends on what we see as the implausible premise that Dr. Durrani fled in part to avoid liability to Mr. Hayes, and on the dubious conclusion that if only his flight had been admitted into evidence, the whole case would have turned out differently. And that amounts to an argument that a flight instruction and flight evidence must be admitted in every case where it might have made a difference, so that the plaintiffs, appellant in this case, can push their cases past the causation barrier that they failed to clear at trial and turn these into cases about whether Dr. Durrani is a good person, deserving of punishment, whether or not he committed actionable medical malpractice or one of these other torts that are alleged against him. What appellant does not do and cannot do is to connect that excluded evidence to an element of any of the causes of action excluded by the jury. In other words, despite that disconnect, the appellant is arguing that the evidence of Dr. Durrani's flight would have supplied somehow the missing causation elements for these claims. But this is dubious, I think, but such inflammatory and prejudicial evidence would certainly have furthered what we have seen as appellant's real goal. And this is not the first time it's been said in front of this court and in front of the trial courts, that proving that Dr. Durrani's treatment of Mr. Hayes met professional standards is not the point. The point of appellant's trial strategy is to paint Dr. Durrani as a disreputable person who should be punished, whether or not he caused an injury to this patient. And one way to do that is to require the trial court to admit prejudicial and inflammatory evidence, in this case, flight evidence.
When would flight evidence be appropriate to be admitted? When would flight evidence be appropriate?
The cases that plaintiff cites in his brief, I think, supplies at least part of the answer to that question, Judge Krause. And if you'll let me skip ahead for just a moment in my notes. Yeah, there are no cases that we can find in Ohio that offer much precedent to support admitting such evidence in a civil case under any circumstances. The two cases that appellant does cite, Smill v. Weiss and Richards v. Office Products Company, 1920 25 and 1977 respectively are not instructive at all. The Weiss course never considered flight at all. And in Richards, and this answers your question, Judge Krause, flight evidence was directly relevant to whether the defendant was liable for a hit and run accident in which flight would be an essential element of making out such a claim. But neither supports the proposition that flight evidence is proper proof of liability in a case involving alleged negligence that happened before the physician left the United States. So the best appellant can do here, and I'm still on your question, Judge Krause, is offer a long string citation to cases from courts in other jurisdictions in other states, few of which were decided in the last 40 years, which deal for the most part with a situation in which the defendant fled after some specific incident, usually a car accident, which makes, I think, the relevance and admissibility of flight evidence more or less logical. But none of these cases, neither of these cases supports the proposition that flight evidence is proper proof of liability, and none of them suggest that that evidence has to be admitted. That decision is left to the discretion of the trial court, and we would suggest with respect that the trial court exercised its discretion properly.
And isn't the evidence in this case that what really prompted his flight from the country was the federal charges that were filed?
The federal charges were filed. Dr. Durrani was released on bond and subsequently fled. And I believe that that's not a matter in dispute. I don't know where in the record that can be found, but it is so commonly understood that I suppose it could be considered to be part of the wallpaper of the case.
But that's not in this record. When you all were litigating whether this flight instruction should be given, those facts didn't come out.
No, I don't believe so.
The reason for the flight.
The reason for the flight did not come out.
Okay.
And with, not for nothing, Judge, I don't think that the reason for Dr. Durrani's flight will ever be conclusively determined, because he's not here and he's never told anybody why he left. But I think that the only plausible inference, Judge, is yours, that facing a federal indictment and many, many years in a federal prison, he thought that the better part of valor was to absent himself from the jurisdiction. We do think that's the likely explanation, and that is the I think understood by all concerned. I want to get, if that answers your question, I want to return to the standard that the appellant is proposing here.
Attorney Sayer, just want to let you know you have about 2 minutes left.
Okay, I will accelerate. Most of the appellant's argument is based on a reading of Evidence Rule 402, which says that all relevant evidence is admissible except where otherwise excluded, and that is true as far as it goes. But it's on the point, except otherwise excluded, that appellant loses his way because he does not consider the two key limiting factors to Rule 402, which are Rules 403 and 404. We start with Rule 403A. Admission of flight evidence would have been improper because whatever limited probative value that might have had would have been overwhelmed by the self-evident prejudice of such evidence, because it suggests, in the absence of Dr. Durrani's presence, that he fled the country for some reason that reflects poorly on his character. That inflames the jury, and that, I think, appellant believes would have been a proxy for causation. Developing negative feelings toward the defendant makes a verdict in in the plaintiff's favor more likely. The trial court addressed this point correctly when it determined that the probative value of the flight evidence was outweighed by prejudice. In this regard, as I run out of time, I would remind the court that not long ago in Durrani v. Setters, this court articulated the rule that for evidence that has low probative value, but high prejudicial value, admitting it is so prejudicial that the trial court abuses its discretion by admitting it. And I'm referring now to Durrani versus Setters, a recent decision from this court, and in particular, paragraph 21 of that opinion, where the court said, thus, despite its minimal relevance, evidence of the license revocation, that was the issue in that case, allowed the jury to improperly infer that Durrani was not credible and that his conduct must have been substandard. But because the evidence could influence the case on an improper basis, we find that the trial court abused its discretion in admitting evidence of Dr. Durrani's medical licenses having been revoked. And this is an issue cut from the same cloth. In Setters, you were dealing with the revocation of a medical license. In this case, we're dealing with whether or not the jury should have been told of his flight. So appellant is asking the court to adopt a test that would essentially read Rule 403A out of the rules of evidence and hold that if evidence has any probative value at all, notwithstanding the prejudicial value of that evidence and notwithstanding how slight the probative value of the evidence, it must be admitted, and the trial court is without discretion in that regard.
Thank you,
That's reason
Attorney Sayer.
enough.
Thank you. Unless
Thank you,
there's any
Judge.
other questions from the panel. Okay, thank you for your arguments this morning.
Thank you, Judge.
Attorney Winter?
Yes, thank you, judges. As far as the reason for Durrani's flight, Dr. Durrani testified for the reasons for his flight in a 2018 case in the federal court before Judge Barrett. And I have the 2019 case, but I can't put my hands on the 2018 case. The reason for his flight was found by Judge Black to avoid the criminal prosecutions, but also the hundreds of medical malpractice cases that were before him. And this concept of me trying to prove Dr. Durrani is an unadmirable man, the point here is not the man, but it's his consciousness of liability that Judge Myers mentioned at the onset.
Can I ask you a follow-up on that?
Please do.
In the criminal context, sometimes a flight instruction is given when one of the issues in the case is who committed the crime. And a court might let in evidence of flight to show the identity of the defendant as the person who committed the crime and allow the jury to consider the person fled in determining whether there's ultimate guilt by who the person was. In this case, though, what element would flight go to? In other words, it's not evidence of the standard of care. It's not evidence of causation. There's no identity issue here on who the physician was that performed the surgery. So other than just general, I think I might be liable, what relevance would flight be?
There would be consciousness of liability, not guilt in the criminal sense, but responsibility for committing medical malpractice.
So is it your position that it would be sort of like an admission that I fell below the standard of care?
It would be evidence, not admission in the concept that we know about it, that we're aware of it, but it's evidence that the jury can accept or reject. These concepts were applied in the two Weinberger cases in Indiana that I've cited to. Those are the most recent and our best effort at finding cases that are relevant of this type of evidence in a medical malpractice type situation. And it certainly went to whether or not that Dr. Weinberger was liable or not. One point.
When you say liable, you're talking about breach of the duty of care.
Yes. Yeah, it's
Right.
evidence towards what he thought.
Mhm.
Dr. Weinberger, Dr. Durrani thought about his conduct toward his patients and his care and treatment of those patients.
And as I understood your argument in your briefs with regard to the cross-examination, I understood that your argument was that it went towards the accuracy of the medical records, of the notations and so on that Durrani had done.
Well, that's one of them. Second one is the credibility of his trial expert witnesses. If in fact Durrani felt the way he did and absconded because he might feel liable or responsible, and these two witnesses are accepting these records lockstep, there's something to talk about to the jury on closing, as well as Dr. Bloomfield and Dr. Siani's discussion of, golly, his interpretation of the imaging is way out of line.
And you
that's
do
what
agree that the standard of review before us is abuse of discretion?
Yes, and particularly the unreasonable aspect of it, Judge, not the other two, but the trial court acted unreasonably in refusing to give us a flight instruction and to argue Dr. Durrani's flight.
Thank you for your argument this morning. Thank you for both of your arguments this morning. We will
Thank you,
take the
Judge.
matter into submission and issue a timely decision. And Attorney Sayer, I wish you a wonderful afternoon.
Thank
And we
you.
get to keep Attorney Winter for one more case.
And may I ask a housekeeping question? My law partner, Philip Williamson, who's going to handle the White argument, has entered the room here with me. You cannot see him.
Okay.
Should he simply take my chair right now? And
That's fine. Yeah, we can accommodate him coming into the case, not a problem.
Okay, well, with that then, thank you, Your Honors. Mr. Winter, good to see you.
Mr. Sayer, good seeing you as always, sir.
And we'll be in touch.
Judges, may we take a 2-minute break?
For the purposes of,
Wetting my whistle and using the facility. When you get to my age, Judge, you need that.
well, if there's no objection from anyone.
No objection,
And
Your Honor.
I would ask maybe before we do that, if the YouTube could be please turned off.